Good morning, everyone, to our webinar today on the ACCC enforcement priorities. My name is Rebecca Wood, and I'm a practice group leader in our disputes and litigation team here at LegalVision. I'm joined by my colleague, Stephen Drysdale, who is a senior lawyer in our corporate and commercial team. Both of us often deal with regulatory issues and including disputes. We look forward to sharing some of our thoughts and experiences with you today. Before we begin, I'm just going to cover a few quick housekeeping items. So firstly, you're going to receive a recording and these slides in your email. We'd really appreciate to hear from you, so if you can submit some questions in the chat box and we'll try and answer them at the end. And finally, we really appreciate your feedback. So if you can please complete the feedback survey at the end of the webinar, that would be great. By joining us today, you are eligible for a free consultation with LegalVision to learn how we can help your in-house team manage your high volume business as usual legal needs. If you'd like to take up this opportunity, just please provide your contact details in the survey at the end of the webinar. So today we're going to be discussing and providing an overview of the ACCC and their enforcement framework. We're going to talk about what are the compliance and enforcement priorities for 2024 to 2025. We'll talk about some of the key priorities that in-house lawyers should be aware of. We're going to talk about what practical steps in-house lawyers should take to ensure that their businesses remain compliant. And we're going to talk about how to deal with regulatory investigations. So to get things started, Stephen's going to talk about the ACCC and their enforcement framework.
Thanks, Rebecca. The ACCC is the Australian Competition and Consumer Commission, which is Australia's peak consumer protection and competition agency. Now, most of its activities are conducted under the Competition and Consumer Act of 2010, which also includes what we call the Australian Consumer Law. The idea of that legislation is to promote competition among business, to protect consumers when they deal with businesses, and to promote fair trading. And when we speak about fair trading, we're thinking about things like, not engaging in what we call misleading and deceptive conduct in the way in which products or services are advertised, in the way in which transactions are dealt with consumers, and also sort of that follow on when things go wrong in terms of, product quality or service quality. The ACCC has, I guess, two main ways in which it tries to achieve this or those goals of the legislation. One is through the use of its, general tools, which is education. So working with businesses to provide them with the tools and guidance to understand what their obligations are. And then also collaborating with consumers, both directly and through stakeholders and other agencies, to advise those consumers as to what their rights are under that legislation, so that both sides of the spectrum are very clear on what they need to do or what they can do. But obviously things do go wrong, whether that's through ignorance, whether that's through intentional sort of trying to skirt around the law. And the ACCC has a range of enforcement remedies available to it to kind of bring businesses back into line and to provide remedies for widespread consumer harm. And some of the things that we'll talk about today are those remedies, including court-based outcomes, court enforceable undertakings, and other sort of financial deterrents or sort of penalties that the ACCC may issue. Rebecca will now sort of dive through the enforcement priorities for the ACCC. Each year, the ACCC will review its compliance and enforcement priorities to work out what its key risk areas are. And then they'll also have a set of enduring enforcement priorities that we'll talk about and touch upon as well. So I'll pass to Rebecca to go through those current priorities.
Great, thanks, Stephen. So look, yes, there has been, the ACCC has published a report that sets out its 2024 to 2025 priorities. So many of the priorities are actually continuing priorities from the 2023 to 22 to 23 year. So firstly, consumer and environmental claims. So the ACCC is going to focus on consumer product safety, fair trading, and competition concerns that are related to environmental claims and sustainability. So there's been a lot of talk certainly in legal circles, about greenwashing claims. So this is certainly something that in-house lawyers should be aware of, and I'm sure Stephen's going to be touching on a little bit later. Second priority area is the supermarket sector. So examining competition, consumer, fair trading and pricing issues in the supermarket sector, particularly for food and groceries. Essential services, so promoting competition in essential services like telecommunications, electricity, gas and financial services. And the ACCC is going to be quite focused on addressing misleading pricing and claims in these essential services, with a focus on energy and telecommunications. In the aviation sector, the ACCC will be investigating competition and consumer issues. In terms of the digital economy, the ACCC will be looking at consumer and fair trading issues such as misleading and deceptive advertising through influencer marketing, online reviews, in-app purchases, and price comparison websites. In the NDIS space, the ACCC is quite focused on improving compliance by NDIS providers with their obligations under the Australian consumer law. In terms of unfair contract terms, this is actually a new focus area for the ACCC. The ACCC will be looking to really stamp out unfair contract terms in consumer and small business contracts. And this development is not surprising as being included in enforcement priority, given the 2022 decision in the ACCC and Fujifilm, where it was determined that 38 terms in the Fujifilm contract were unfair terms, and these were automatic renewal, excessive exit fees, and unilateral price increases. In terms of consumer guarantees, the ACCC is looking at improving industry compliance with consumer guarantees, focusing on consumer electronics and retailers' misconduct regarding delivery timeframes. And finally, product safety issues for children. So the ACCC is going to be looking closely in terms of consumer product safety with a particular focus on nursery products, including furniture, infant sleep feeding, and infant sleep products. So Stephen's now going to talk about some of the key compliance obligations that the ACCC will be looking at as part of its consumer law enforcement priorities.
Thanks, Rebecca. And we'll start with probably the most common one that most consumers will face on a day-to-day basis, and that's whether a business is upholding those consumer guarantees, which are those minimum protections in respect of goods and services. And these are typically non-negotiable, especially when we're talking about services or goods that are designed for or intended for personal, household, or domestic purposes. So if your business is sort of in that space, that's always going to apply. If you're in I guess in a B2B context, the regime is still likely to apply, but there are some sort of caveats, which we won't be touching on today, but that's just something to keep in mind, that it isn't just I guess, people who, if your services are for people, sort of at home and their sort of day-to-day lives, it's probably important to consider that, you'll have a higher degree of scrutiny or a higher degree, but in terms of B2B contracts, you're not exempt either. So this is sort of something that needs to be considered across the board. Now, it's misleading, or it's illegal to mislead consumers about their rights. So whether they are entitled to, say, a replacement if the product that they buy is unsafe or not of acceptable quality, or, for example, if you carry out a service without reasonable care and skill, that they have rights to cancel the contract for that sort of piece. Now, what we see a lot of the businesses who will have, signs up in stores or policies on websites that are very broad sweeping, no refunds, things like that. Those are really obvious catches because you do have rights in certain cases, but also from a more nuanced standpoint, even getting things right around when we give express warranties to customers, like manufacturers' warranties, making it really clear that we have the necessary language that we need to not mislead consumers, that in addition, this warranty is in addition to what we're looking for. So those are the sort of things that the ACCC typically will pick up on. In terms of environmental claims, as Beck mentioned, this is a huge focus, and there has been some enforcement action already in the greenwashing space. When we talk about that, we're talking about things where a product or service is maybe overstated in terms of the sustainability or environmental friendliness. That's commonly seen in things like, 100% recyclable, where the product itself may not actually be accepted by all local councils, or maybe it's the bottle that's accepted but not the cap or the label and things like that, which small things like that are essentially misleading, and the ACCC will be taking a look at those as well, especially where there's been a sort of a widespread exposures to consumers of that sort of misleading or deceptive conduct. So I think the grocery space, for example, any sort of consumer goods, where there's a high volume of products out in the market and widespread, widespread advertising, those are going to be more likely to be picked up by the ACCC, but there's no sort of, carve out for any particular industry. As Rebecca mentioned as well, unfair contract terms are a big one. I mean, there's also been a recent change in the law around, what unfair contract terms apply to. There's been the court decisions around providing clarity as to what unfair contract terms might exist in what we call standard form contracts. So those standard form contracts are take it or leave it, commonly seen in sort of online and software space, but very common too when you think about those times where you try to negotiate with a counterparty and that counterparty hasn't been willing to budge on any sort of essential terms or key terms of that document, especially around liability, risk, things like that, where there's actually not a legitimate interest for the business to enforce those claims. For example, very broad indemnity across, breaches of warranties, breaches of contract provisions may not actually be a legitimate interest when there could be other routes of enforcement or remedy, to sort of rely upon. Whereas, using them for maybe sort of third-party events might make sense, and there may be a legitimate business interest that can support the use of, a very imbalanced term like that. It's important to note too that it's unlawful to rely upon or enforce those terms, so penalties do apply. The date for that, I think, is November 9th of last year. So any contracts that are entered into after that date or renewed after that date, this sort of enhanced unfair contracts term regime will apply. And same thing, it applies in small business contracts as well. So those are contracts with businesses who have fewer than 100 employees, or I think an annual turnover of around 10 million in the previous income year, which is a very broad range of businesses. Influencer marketing is a big one. The ACCC has just conducted a review into influencer marketing. They've had a look at across sort of a wide range of industries as to whether influencers are disclosing any sort of affiliations with businesses. It's important that those disclosures are being made because a consumer may be misled if they're not aware that there's some form of affiliation involved. And that also applies when they've been given free products and non-cash incentives. So it's not simply about whether or not there's been a payment of currency to that influencer, but any sort of in-kind or non-cash payment or contribution to an influencer is going to be a form of affiliation that needs to be disclosed. And then the last two on those consumer pieces that the ACCC are really focusing on, online reviews. This is sort of related to the influencer point. So it's obviously illegal to go in and create fake or misleading reviews about your own business, but it's also illegal to suppress or edit negative reviews that are genuine. So if someone leaves a bad review, but there is a basis for it, if something wasn't up to standard or there was a genuine issue with the product, it would be unlawful to try and hide that, review, or to try and drown out that review with sort of fake positive claims. It's also misleading and deceptive if you're offering an incentive for positive reviews and you're not disclosing the fact that that review was incentivized. So again, comes back to the point of, cash or non-cash incentives. They still need to be disclosed when a consumer is providing a review. So if you are engaging in any sort of those activities, it's really important that you're clear and upfront with, those participants that, hey, these are the expectations, or in your contracts, having really clear obligations to disclose when they post reviews that they have been incentivized to provide that review. And then just lastly, on the NDIS providers, this is one that's come out quite recently. So this is the announcement of a fair pricing task force between the ACCC, the NDIS Quality and Standards Commission, and the NDIA, so the Disability Insurance Agency. This is really focusing on NDIS providers who are charging participants of the NDIS scheme more than they would charge non-NDIS, consumers. Now, that's obviously unlawful on a number of fronts, but they're seeing it as a widespread issue at the moment. Not only is it a breach of sort of the competition and consumer law framework, but also the NDIS rules. So the idea of establishing this fair pricing task force is to kind of consolidate the resources of these agencies, to put a real focus on NDIS providers, both from an education and enforcement standpoint, and provide also as well updated NDIS rules to make it even clearer around what can and can't be done. And it's important, lastly, to note too, that if you are an NDIS provider or in that sort of space of providing any sort of, I guess, health or regulated service, there can be times where you can be regulated by, sort of simultaneously by the NDIS and the ACCC, or maybe one or more enforcement agencies. So it's just really important to understand that if you are in a regulated sector like that, what your obligations are under maybe two corresponding compliance frameworks. I'll pass to Rebecca now to summarize some of those enduring enforcement priorities that I mentioned earlier. So these are the sort of forms of priorities that are enduring and that the ACCC kind of have on their books from year to year.
Thanks, Stephen. Yeah, look, there are a certain number of priorities that the ACCC consider what their conduct is so detrimental to the consumer welfare and the competitive process that they're treated as long-term enduring priorities. So firstly, cartel conduct and price fixing. So this will always be an ongoing concern for the ACCC, and I understand that the ACCC actually has quite a number of active matters before the court in terms of price fixing. Certainly there was a finding in 2023, steel manufacturer BlueScope was ordered to pay a $57 million penalty for attempting to induce a number of steel distributors to fix prices for steel products in Australia. So this has been the highest penalty that's been imposed to date in this area, but it just shows how serious that this matter is for the ACCC. Product safety will always be an ongoing priority for the ACCC because of the serious harm to consumers that can occur when product safety issues go awry. Consumers experiencing vulnerability or disadvantage. So the ACCC is really concerned with how businesses advertise or deal with consumers, particularly in circumstances where those consumers may be experiencing a period or ongoing vulnerability. So the ACCC is quite conscious of looking at businesses that might be engaging in complex or confusing marketing, and that makes it especially difficult for people who are vulnerable. Now that could be through, disabilities or, people who perhaps, English is not their first language. So there's quite a wide scope of persons that could be considered in a vulnerable state. And it's just really focused on making sure that businesses are not necessarily taking advantage, but also making sure that they're pitching and that their information is accessible by people who are vulnerable. Conduct involving First Nations Australians continues to be an enduring priority. And recently the ACCC has highlighted that it's going to be establishing a First Nations coordination outreach and advocacy team to further support its work in this space. In terms of small businesses, the ACCC has highlighted the enforcement of competition and consumer laws affecting small businesses and the ongoing role that industry codes play in this sector. And finally, scams. So Scam Watch will be continuing to be an enduring priority for the ACCC. So what the ACCC is doing in this space to continuing to support the National Anti-Scam Centre in its mission to essentially disrupt the harm that is caused by scams in the community. So I guess putting this all together, Stephen's now going to speak about some of the key action items that in-house counsel should think about in terms of these priorities.
Exactly. There's a lot to consider. There's a lot of obviously priorities that the ACCC have sort of be across. So one of the key ones that we can sort of focus as in-house lawyers to try and mitigate. Now, the obvious starting point are standard form contract templates. So looking through the business and determining what contracts do we have as a default that are take it or leave it. So if you're in a software business, it might be your sort of online subscription terms or any sort of, click to accept terms that you have implemented with customers or suppliers or any other third parties that you work with. And then there's also the kind of, I guess, that introspective review into how does your sort of legal team or how does your business actually approach contract negotiations with third parties? Are you open to negotiation? Do you sort of have a very much these are our terms and that's it type approach? And if you sort of do have that kind of take it or leave it approach, then it's really important, obviously, for you to go through those templates and really kind of consider what clauses in there are quite imbalanced. Even if you think from the outset, well, I think there's a fair reason, or we've always had that, that's how I've always done it. It's really important that you just sort of go through and extrapolate those, I guess, terms that are skewed towards you and actually really sort of think about them and challenge, is this actually necessary? Do I actually need an indemnity that is that broad, or are there ways in which I can take that indemnity and maybe, or that liability clause and maybe kind of balance it up a bit. Maybe I can reduce the liability to the extent it was, caused by me or my staff, things like that, that might, I guess if an ACCC, if the commissioners of the ACCC were actually looking at the matter and say, well, you've taken steps, or we can see how you've tried to balance that, even if it is an unfair contract term, potentially the penalties for that may be, that may be considered, I should say, when factoring in what enforcement action will be taken. Advertising is the other big one as well. How do we be across sort of all the claims that the business is making to the wider market? Some legal teams will be very heavily involved in that advertising and ad review process. Some won't be. Some may just be that middle ground approach where there's a sort of process in place with an escalation framework. No matter which I guess model is taken within your particular business, it's just really important that if you are working with non-legal teams who generate these claims and we're putting these claims out to market, that you do implement some sort of, maybe training is a big one, or having sort of a standard playbook. It is something we often see as well, where these are the claims that, we like, these are the claims that we don't like, and why that would be, or sort of explain to the business why that is the case and why we can't say certain things and provide that ongoing training. Any arrangements that you have with your competitors as well are really important to scrutinize, because we're looking for those cartel signs. So we see this a lot in businesses that are maybe a supplier of a product, and then they also sell to their, they sell to distributors, and maybe also then compete with those distributors within the same market or territory. So we just need to be really mindful of, what have we got in place in terms of understandings, in terms of, market shares, prices, things like that. And really think about, is this something that we need to kind of escalate and get external input on to see whether there's a risk of this being cartel conduct? Because as mentioned, it's important to remember that this is a high degree of offence. There's potentially criminal enforcement involved, and also it's not it doesn't require that degree of formality. It can just be an understanding at a cocktail party that will split the market, and then you've got cartel conduct. I've already touched on training, so that's a big one for your internal legal and non-legal teams around education and compliance, especially if you've got customer service teams. They're really good to get across in terms of how they interface with consumers and kind of advise them about faulty product or defective services, things like that. And then lastly, on product standards. So if you are in a business dealing with, tangible goods, you always need to meet the mandatory standards, but you should always try and strive for voluntary if you can, so that in the event something does go wrong or there is an issue and you are, so your business practices are examined, it's always good to be at a front foot with the ACCC that you have strove for kind of best practice compliance rather than bare minimum, because that's something that would be taken into account when the ACCC is determining what enforcement remedies may be taken against you and whether that is escalated to a court-enforced or court-based remedial action approach. Now, on those consequences, on those enforcement actions, Beck's going to touch through the consequences of non-compliance and what those enforcement remedies and penalties might even look like if the ACCC does determine that something has gone wrong.
Yeah, thanks, Stephen. So look, we've helped a number of clients sort of navigate these enforcement steps when they've had the lens of the ACCC put upon them. And there are obviously a lot of priorities for the ACCC. There's a lot of businesses out there. And I guess the way that they will focus their attention is, determining, when it's appropriate to take enforcement action. And the factors that they will take into consideration is whether or not the conduct is of significant public interest or concern. So, whether it's falling within their enforcement priorities would be a starting place. They'll want to focus on conduct that results in a substantial detriment to consumers or small businesses. So, they're looking for matters that, taking action will provide some high impact. They might consider where the conduct is being undertaken by some national or larger traders, and so the potential for greater consumer detriment is higher, and that the likelihood that enforcement action will influence the market. Again, they might be looking for conduct that involves a significant or new emerging marketing issue. So where the ACCC, again, their action is going to have a deterrent or at least an educative impact will be an important consideration in deciding whether to take some enforcement action. And finally, if there's some aspects of the law that are a little bit ambiguous, and action by the ACCC might in fact help clarify the law, that might be another area where another key factor that will assist the ACCC in determining, when and against who to take enforcement action. So if the ACCC picks up on a breach of the Australian consumer law, or some enforcement action may be necessary, there's a few routes that enforcement action might take. Generally, there's an information gathering phase. So, letters will be issued by the ACCC confirming that there's an investigation. There'll be the opportunity for an information exchange to find out and dig deep into actually what's happened. It's very useful to kind of get some legal assistance with that Q&A process, because it can really be useful to kind of, understand where the ACCC may be going, but also just to understand what things you might want to put into play to try and mitigate some of the action that may be taken down the track. So administrative resolution, might be an option where there's a low risk impact scenario assessment has been taken. So, for example, there's been some breaches of the Australian consumer law in terms of some misleading marketing. The issue has been fixed up. There's not a huge impact on the market. The ACCC might be happy to resolve the matter with a signed commitment from the business that they've, learned from the experience, and that they're going to implement some practical changes to ensure that this might not happen again. If there's been some action that the ACCC determines some formal sanction is necessary, infringement notices may be issued. So this will require the payment of a penalty to be paid by the party that's being investigated. Now, in Section 87B, enforceable undertaking might be suggested or required. So this is a court enforceable undertaking that will be on the public record, and I see this quite often as an alternative to an infringement notice, or sometimes they go hand in hand. So where they think the conduct is quite serious, but not serious enough perhaps to involve court action, an enforceable undertaking will be required, and that also might need to be publicly available, perhaps on the business's website as well, together with the payment of a penalty fee. Now, for the matters that the ACCC considers the most serious, or for example, they want to use it as an opportunity to show other players in the market, to educate the community, or perhaps there's some ambiguity in the law, as I mentioned above, litigation and court action might be the vehicle by which the ACCC decides to pursue the matter. So again, it's going to be more likely where the unlawful conduct is on a larger scale, and by large and national businesses. So, for smaller businesses, the enforcement action is more likely to be the infringement notices and the unenforceable undertakings, but that's by no means a guarantee. There's been a number of recent court cases that demonstrate that the ACCC is investigating and litigating matters that fall within these priority areas. So some recent decisions that demonstrate the ACCC taking action in relation to misleading and deceptive conducts in terms of refunds, replacements, and warranties. So consumer warranties for faulty and defective products include the case against Tiger Mist. So in this case, infringement notices were issued and a $26,000 penalty was payable for misleading statements in respect of a returns policy. Fitbit was hit with an $11 million fine for false representations about refund and replacement rights. Mazda was recently hit with an $11.5 million penalty, and they actually had to pay 70% of the ACCC's costs for making misleading representations about refund and replacement rights for faulty vehicles. And actually just this month, Qantas was ordered to pay a $100 million penalty for breaches of the ACL. The Qantas was also agreed to provide a court enforceable undertaking to pay about $20 million to over 86,000 customers. So in that decision, Qantas made admissions that it misled customers by advertising tickets for sale for flights that it had already determined wouldn't go ahead, and cancelling flights without promptly telling ticket holders about their decision. At the moment, the ACCC has commenced actions against Emma Sleep, eHarmony, Energy Australia, Express Online, training for misleading representations on their websites and social media. And the ACCC has issued infringement notices and accepted court enforceable undertakings from a number of businesses like Crusader Caravans, Pet Circle. And again, these just demonstrates the different use of enforcement tools for suspected violations of the Australian consumer law. In terms of the greenwashing space, the ACCC has recently accepted its first administrative outcome, which was a court enforceable undertaking in relation to greenwashing claims. So this was in relation to an investigation into the company Moo and their claim about products being 100% ocean plastic. So this just summarises, what's happening in this space. And, I think there's going to be a lot more to see over the coming months and year. Now, look, we've sort of reached the end of the substantive part of the seminar. So Stephen's just going to wrap up things with a summary of some key takeaways.
Thanks, Rebecca. So in terms of the key things to take away from today's presentation, it's important to consider those key priorities, both the current and enduring ones, and whether your business falls into these priorities. Like I said, pretty much every business will need to consider some of those ones around consumer guarantees, UCTs, and the like. Look out for those standard form contracts, review them for those unfair and imbalanced terms, and then ensure that your non-legal department's provided with that tools and training that they need to substantiate advertising claims and anything else that you identify might fall within sort of the enforcement priorities. Like, for example, you're an NDIS business, you want your frontline personnel to be across what they can and can't do in terms of setting pricing and contracts and things like that. And then obviously if you do receive a notice from the ACCC, it's important to seek legal advice. We have seen clients who will try and maybe try and handle those conversations with the ACCC themselves, and then sort of come through sort of at the tail end when it's already at kind of the decision-making phase for the ACCC. So the sooner you kind of can get in touch with someone, get a second opinion and steer those conversations, sometimes the better those outcomes can be for the business. Now, that concludes the main part of the webinar. We do have a publication that you might find useful. You can download it in the handout panel or by scanning this QR code. It's our General Counsel Toolkit. Just leave that code up for a second. And then we also have some upcoming events that you may be interested in. So our next webinar is sponsoring overseas workers for your hospitality business. That's on the Thursday, the 16th of May. You can register with the link below. So that's just legalvision.com.au/events. Now, for those in-house counsel on the call, we're going to answer some questions shortly. So if you do have questions, or for anyone, I should say, any questions, please submit them through the Q&A box. I'll give you a minute or two just to do that. And then while you're submitting them, let me take a minute to tell you about our desk extension product for in-house teams. So having spoken to hundreds of C-suite and in-house counsel, we understand that it's kind of hard. You've been pulled in many directions, and you're required to provide input on business critical and strategic matters at an executive level, while also managing your sort of high volume business as usual legal matters. And obviously, we all have tight budgets and an even tighter labour market to deal with. So under our desk extension model, LegalVision can assist you with all the business as usual legal needs. That allows you to kind of free up your time cost effectively to focus on those high level critical matters and leave us to sort of focus on the day-to-day, run-of-the-mill stuff that you want to sort of take off your plate and be able to redirect your energies. Our lawyers invest a lot of time in getting to know your business upfront, understanding what's important to you, developing playbooks to understand what you like and don't like when it comes to contract negotiations, and essentially work as an extension of your in-house legal function. So if you want to learn more about how this desk extension offering can help you, you can provide your details when the survey appears at the end of this webinar. And don't forget as well, there's that opportunity to take up the free consultation after this webinar too, which, if you have questions about desk extension, you're more than happy to use for that purpose as well. In terms of Q&A, so we had some pre-submitted questions come in, so I'll start with those. I think there was a question here that Rebecca can answer, and that was whether there were any particular enforcement priorities for food products or I guess any sort of food-related businesses. So I'll leave that to you, Rebecca. Take it away.
Yeah, look, certainly there is. So, as I said earlier in the presentation, supermarkets and food pricing is going to be something that's on the agenda. So certainly it's going to be something that's going to be under the lens of the ACCC in terms of their key priorities.
Perfect. And then there was another question as well around, sort of if I am making environmental claims in my business, so what sort of things should I be looking for to try and make sort of trustworthy environmental claims, which I'm happy to speak to. It's actually quite helpful because the ACCC did publish some guidance last year around sort of the 8 principles that they consider important when making environmental claims. So, obviously the first one, they need to be accurate and they need to be truthful. The second one is that you need to have evidence to back up your claims. So you can't just put them out into the universe. You sort of have to have that evidence before you go and take those claims to market. You can't retrospectively prove that what you said was true. It's really important not to hide important information is the third principle that the ACCC has advised. So, using small print to try and caveat really bold and sweeping environmental claims won't be enough. You need to be really upfront so as to not mislead consumers. The fourth one is to explain any of those conditions or qualifications on your claim. So, if it is a broad claim or there are some caveats, like, for example, it's, this product is recyclable, but maybe certain elements aren't, making it really clear, that those conditions or those carve-outs do exist. And then going back to that third principle, not hiding that important information. The ACCC also recommend avoiding sort of broad sweeping phrases like sustainable, eco-friendly, environmentally friendly, or green. They can be really hard to substantiate because they are quite broad. And so you should aim for narrow and tailored claims. And that goes for most advertising claims generally, is the more narrow and focused they are, the easier they are to substantiate and the less risk of the ACCC sort of taking maybe an enforcement approach against you when it comes to sort of reviewing those claims in market. And then just quickly, really clearly around, or really clear and easy to understand language is obviously the priority. Visual elements should not give the wrong impression. So if you do have a product that is, maybe very bad for the environment, but it's, covered in green packaging with, flowers and plants and animals, that can give a misleading or deceptive impression to a consumer that the product is environmental when in fact it might not be. And if you are in the process of doing some sort of, internal sustainability transition in your business, becoming more environmentally sustainable or friendly, being really clear about, how that process is going. If you're wanting to make representations maybe to investors or to the wider market about what your business is trying to achieve, being really open and transparent and not sort of trying to, I guess, make absolute, commitments if you're aware that there may be things that pop up, and obviously factoring in as well that sometimes we can't predict what might happen, and it may take longer to achieve, that sort of move to a more sustainable business environment than maybe what was anticipated. So yeah, those are sort of the things that the ACCC are looking for there. And then I think we had, oh, sorry, you go, Rebecca.
Oh, look, I was just going to say, we've had some really good questions pop up that are probably just not within the scope of the seminar, but they are great questions. So we'd love to chat to you a little bit, chat to you about them. So if you wouldn't mind, just popping your details in, and, happy to take those questions up as part of a consultation.
Perfect. And then just that reminder, so you can book a call with our enterprise team if you want to, have a conversation about anything today, or if you want to understand how LegalVision might be able to support you to understand, to reduce your in-house team's workload. And then just as a reminder, so within the next few days, everyone who's registered for this webinar will receive a copy of the slides, recording, and the publication. So keep an eye out for those. But otherwise, if there are no further questions, we'll let you get back to your day. Thank you so much for joining us, and hopefully we hear from you soon.
Thank you.